I'm Laiba Assad.
And I'm Aaron Gao.
We're 1L podcast members of the McGill Law Journal podcast. You're listening to the Ethics and Legality of Police Tactics Used During Public Demonstrations, an MLJ podcast. After the killing of George Floyd, countless protests against racial injustice and police violence arose across the United States. Although these protests were for the most part peaceful, what started making the headlines was the violent way in which police and federal agents were responding to them. In this episode, we'll be discussing the various tactics used by police during protests for racial justice and their legality, both from a general legal standpoint and from the American context. We'll also be looking at the extent to which police officers can be held responsible by courts for their handling of protesters. To illuminate us on these topics, we'll hear from Professor Karen Pita Loor. Professor Loor is an associate clinical professor at the Boston University School of Law. For the past 3 years, her research has focused on government response to mass protests. She has been interviewed and quoted as an expert on this and other topics by multiple media outlets, including the Wall Street Journal, the Boston Globe, CTV News Toronto, USA Today, Huffington Post Live, WBUR, and major city newspapers. Her newest scholarly article, entitled "If the Conduct is Expressive, Is Police Force Excessive?", which examines the 2020 protests of George Floyd's murder and the constitutional implications of law enforcement's brutal response, will be published in Southern California Law Review in September 2021.
Over this past summer, countless videos of police violence directed towards protesters went viral. We asked Professor Loor to describe the types of tactics that police departments use during protests, and particularly those that have come under the most scrutiny during the protests for racial justice.
Just this past summer, American cities erupted in protest after the video of George Floyd's murder by police officer Derek Chauvin and his police officer accomplices went viral. While there were some places where police responded with solidarity, for example, kneeling with the activists, in way too many sites, law enforcement assaulted activists using military weapons and tactics to confront overwhelmingly peaceful protesters, essentially acting like warriors confronting enemy forces. Police sprayed people and crowds with pepper spray and tear gas. They blasted them with rubber bullets. They threatened them. They threw concussion grenades at them, used stun guns against them, and long-range acoustic devices. Law enforcement did this either indiscriminately or sometimes even worse, to inflict the greatest possible level of harm. You may have seen a YouTube video of a New York City police officer tearing off a protester's mask that he was wearing to protect himself from COVID and pepper spraying him directly on the face. Denver police intentionally, for example, shot rubber bullets that are only supposed to be aimed at the ground at people's heads and groins. Minneapolis police shot a rubber bullet at a journalist's face. And even though these weapons are called less lethal, I want to be clear, they can cause severe injuries and can even kill. For example, the journalist in Minneapolis is now permanently blind in one eye. In Dallas, a protester lost his eye, while another one had his cheek shattered. A quick search in the internet just shows severe injuries like bloody faces, injured legs, and arms. Police not only targeted protesters, but also folks that they knew were journalists and medical personnel providing medical attention to injured protesters. Now, I am speaking of the physical injuries, but of course, there are injuries to these activists' freedom of speech and assembly rights. Just like the Canadian Charter of Rights protects freedom of expression, the First Amendment of our U.S. Constitution protects freedom of speech and assembly. In U.S. courts, part of the question is whether the actions of police chilled the speech of activists. You can see how this level of police violence that I have just given you a window to, this brute force and militaristic tactics makes people afraid to go out and protest.
It has become commonplace among American cities to impose curfews and to employ kettling to control public demonstrations, which can culminate in police detaining or arresting protesters. Professor Loor explained the constitutional implications of curfews and kettling with regards to protesters' First and Fourth Amendment rights.
Kettling is when police, usually in riot gear, confine a crowd of protesters to a space by blocking their escape. Protesters cannot escape without crossing past police. Police use it as a crowd control tactic. There are multiple problems with this strategy. I experienced some version of it myself while protesting over the summer in Boston. I was getting alerts on my phone saying that the Boston mayor was warning protesters that they needed to leave the protest area and go home or face the police because there had been property damage, broken windows, and a burned police car. And he was saying that because of this, no one now had a right to be out protesting. My partner and I decided that we were ready to leave because we did not want to be confronted by police. We had already ran away from tear gas, but we could not find a way out. We were trapped because every street where we wanted to exit to go home, there was a line of police many rows deep with riot gear deploying tear gas at people. Now, this was not quite like kettling because we were not tightly packed, but it was still frightening because we could not find our way out. So I will go over the constitutional implications of kettling. But to start with, it is dangerous to crowd people into a small space, particularly during the pandemic. Even in regular times, police don't just kettle protesters, but they also tear gas them simultaneously. This prolonged exposure is not only more painful, but also more likely to cause respiratory damage to protesters. To now get back to your question about the harm to the First and Fourth Amendment rights, the Fourth Amendment protects people's rights to be free from unreasonable seizures, like Section 8 of the Canadian Charter of Rights. That means freedom from unreasonable detention, from unreasonable arrest, from excessive force. Kettling impinges on both First and Fourth Amendment rights. Particularly on public streets, folks are entitled to protest. Police should not impede their freedom of speech and freedom of movement by limiting where they can protest, particularly if law enforcement cannot articulate a credible public safety concern. Lack of order, disorder, is not the equivalent of a public safety concern. Police violate protesters' First Amendment rights when they force them to stay in a tight area without providing them with alternative places to protest. Often, police kettle protesters in an area and then persist to arrest them in large groups. These mass arrests violate the Fourth Amendment because the police do not have probable cause to believe that the people they are arresting were involved in any type of crime. Also, their detention via kettling violates the Fourth Amendment because the police do not have a reasonable suspicion that they were actually involved in criminal activity at all. Their protest activity is lawful, and it is a fundamental right. You also ask about curfews, and I want to talk about that. There have been more curfews than ever associated with the protest of 2020. I spoke to a protester in LA who told me about a 4 p.m. curfew in Los Angeles. Police use curfews and kettling in conjunction, kettling protesters into an area right before a curfew so they can't leave when the curfew starts, and they arrest them en masse for violating the curfew. Now, courts will usually find curfews unconstitutional unless the local or state government has previously declared a state of emergency. The problem is that a state of emergency is way too easy for state and local executives to enact. These executives just say that there is a public safety threat, and courts really don't question it, even when what they're calling a public safety threat is the voice of public dissent, public anguish. So once an emergency is declared, it is easy to enact a curfew. You just need a good faith basis. And a curfew becomes essentially a license to arrest during those hours. Curfews end up criminalizing behavior that is innocent, like just being in public, or regularly protected by the Constitution, like protesting. I have argued before in my writing that states of emergencies and curfews should not be so easily enacted in response to protests because of their direct effect on the constitutional protest activity.
Alongside state and local police, many militarized tactics have been employed by the federal law enforcement agencies deployed by the Department of Homeland Security to cities like Portland during protests. Officials in Washington have relied on 40 U.S. Code 1315 to justify intervention. We asked Professor Loor to weigh in on the legal, constitutional, and ethical boundaries to federal intervention during protests.
40 U.S. Code Section 1315 gives the Secretary of the Department of Homeland Security the power to enlist federal agents to protect federal property. In the Trump administration's Operation Diligent Valor, federal agents from the Border Patrol, from ICE, from the U.S. Marshal Service have been deployed to various U.S. cities to allegedly protect federal property from what the administration has called quote-unquote violent extremists. Importantly, state and local authorities did not request the help of the federal government, and instead they have opposed it. As a matter of fact, these jurisdictions have responded by suing the administration to get the federal forces out, with the governor of Oregon actually calling out federal agents causing chaos in Portland as occupying forces. Although Section 1315 provides the federal government the legal authority to protect federal property, the manner that the Trump administration has used it to take over widespread policing of protests has been unprecedented. According to the principles of federalism under the 10th Amendment of the U.S. Constitution, local and state authorities are the first responders to any incident or crisis within a city or town, and the federal government should not interfere without a request from the governor. Trump has turned federalism on its head and behaved more like an autocrat than an American president. Besides the usual barrage of less lethal weapons that I have discussed previously with you, federal authorities rode in unmarked vans and jumped out in camouflage and forcefully grabbed protesters, dragging them back into these vans in Portland. Federal prosecutors then charged the protesters with crimes in federal court. The federal government has not previously used Section 1315 in this way, charging people with crimes. Finally, the crimes that protesters are arraigned on belied any claim that they were being violent. They are often charged with failure to obey a lawful order or disorderly conduct. Some protesters have been charged with crimes that do sound more violent, like assault on federal officers, but the files for these protesters' cases often contain absolutely no detail of the crime or of who even the alleged victim is. When the files do contain details, they don't sound like what we would normally think of as an assault. For example, protesters charged with assault were accused of shining a laser through a courthouse window at the eyes of federal officers. That doesn't sound like assault to me. In addition, courts are then conditioning release from jail on these activists, promising that they will not go back to protest during the pendency of their case. This is an unconstitutional condition of pretrial release that activists have felt forced to agree to because they needed to get out of jail.
One aspect that is unique about the protests for racial justice is that police are more directly involved in the issue itself, and most are opposed to the protesters' viewpoints. For example, a 2016 Pew survey showed that 80% of police officers believe that the country does not need to make more changes to ensure that Black Americans have equal rights with white Americans. Professor Loor talked to us about the amount of responsibility when assessing the actions of particular departments and officers that should be placed on discretionary decisions rather than the legal authority provided to them.
So I want to say that the problem of violence in policing is not the problem of a particular police department. It is a problem of police culture, of too much judicial deference, and lack of oversight and accountability. Police culture is violent. Police are not trained to de-escalate, but instead trained with warrior cop mentality that prioritizes social control, particularly of marginalized and Black and Brown communities. In terms of judicial deference, courts provide too free rein to police on the streets. The law provides police with too much power and authority. Where a neighborhood is a high crime area that warrants law enforcement surveillance and harsh policing practices, whether a person's actions are suspicious, even when they're not criminal, whether the person should exit her car for minor traffic stops. Courts trust police too much, and blindly rely on claims of police experience to justify these discretionary actions that force people into encounters with police. When a police officer hurts someone, even kills them, the court inquiry into the reasonableness of the law enforcement officer's actions is extremely deferential, giving way too much leeway to the fact that police are, quote unquote, forced to make split-second decisions in circumstances that are tense, uncertain, and rapidly evolving. This inquiry undervalues the safety, well-being, and even the life of civilians in the face of police. This is particularly so for Black people, who are most likely to be targeted and treated violently by police. For example, a study by a policing agency itself in Boston, which is my home, has found that 70% of the people who police stop and ask random questions to are Black people, even though only 25% of the folks in Boston are Black. So the numbers are clearly off, and Black people are overrepresented in interactions with police when there is no suspicion of criminal activity at all. What's more is that these statistics, they're not aberrational or unique to Boston. This is what is happening all over the United States, in all our cities and towns.
It's become clear that police are more violent and forceful in their handling of racialized and marginalized protesters than in their interactions with white American protesters. Additionally, law enforcement agents accused of excessive use of force during protests are frequently cleared of any wrongdoing by the courts. Interdepartmental discipline is unlikely to be a more promising avenue for change. Professor Loor spoke to us about what has contributed to the lack of success in holding officers accountable, including in cases involving racial discrimination, and what changes she would like to see in courts' approaches.
Police treat Black and white protesters differently. Protests of people of color are more likely to attract police attention and aggression because police are primed to see Black and brown folks as violent. They also know that really Black lives are devalued by our society and in our legal institutions. But not only that, even when Black and white people are protesting side by side, like we have seen in the 2020 protests, which have really been the most racially diverse movement in the US, Black activists are still treated more violently and are the ones that end up arrested and in jail. I have, for example, arrest data from the summer protests in New York City that show that 70% of the people arrested and charged during the first week of the protests were Black, despite the fact that the largest group of protesters were actually white. I would like courts to take into account the race of the victims of police violence, not cabin excessive force claims only within the Fourth Amendment so that the court only assesses the single interaction, but instead looks at the history of disparate and violent treatment of people of color. On the specific question of violent policing of protesters, the current excessive force test is completely misapplied. Protest activity is privileged and revered according to the American constitutional values. The test that the court applies in a protest case should take this into account and more strictly review police conduct by carefully inquiring what is required by freedom of expression.
Successful court cases have been rare and settlements even less common, as Professor Loor explained. However, she provided some avenues for encouraging accountability.
The law needs to change so that it is not practically impossible to win civil rights actions against police officers, and also to hold supervisors and entire police departments liable for First and Fourth Amendment violations. Some suggest that civilian review boards, where lay people review instances of police misconduct rather than police internal affairs, more transparency about investigations of police misconduct may also prove helpful. These investigations are usually quite secretive, and it is challenging even for a defense attorney, where the police officer is the main witness against their client, to obtain this information. Information about police misconduct should be made public just as a matter of course.
In response to protests, some studies have shown a willingness to implement at least minor reforms aimed at addressing police brutality. Focusing on police tactics during protests, Professor Loor spoke about changes she has witnessed at a local level and approaches she hopes will become more prevalent in the future.
I am really excited to be working with the city of Berkeley, California, on reforms and legislation that would make it more difficult for the local government to enact a curfew in response to protests. Law enforcement would have to satisfy a higher burden and show that there is a real danger of serious bodily harm or severe property damage, such as arson, before a curfew can be enacted during protests. The proposed reforms recognize that a curfew or another government action enacted or executed in response to protests directly impact an individual's First Amendment right in a way that other curfews or government actions do not, when taken in, for example, in response to an earthquake or a forest fire. Once Berkeley adopts these changes, it will be the first jurisdiction to recognize the really direct impact of these curfews on protesters' speech rights and to protect these rights accordingly. Also related to protests, jurisdictions are forbidding or restricting the use of less lethal weapons. More generally, cities are also moving to defund or decrease the budget of their police departments and instead refocus that money in non-law enforcement programs and resources for over-policed communities. Cities are also increasing transparency of police disciplinary actions, like I talked about a little bit ago. In a bold move, Colorado has banned qualified immunity protection for police. And I mentioned to you that qualified immunity was part of the reason why a lot of these cases, excessive force cases, were dismissed in the protest context. Since I have done most of my work in the area of protest policing, my hope is that cities, towns, and states begin to evaluate how law enforcement engages with activists and rein in police during actual protests. Mayors and governors should institute a council of experts and stakeholders that work together to guide first responders as they engage with the community during actual mass protests. The goal of this council would be not only to protect the public, but also to protect and enable protests, since that is supposed to be the job of law enforcement. The council would include folks knowledgeable in the area of civil rights, emergency management, de-escalation techniques, community organizing, and principles of anti-racism. We are in the midst of the largest protest movement or uprising in the history of the United States. What we are doing as a nation and in our cities and towns is not working. We need an alternative way to manage this transition towards hopefully increased racial justice that is more protective of the right to protest and does not prioritize order and state control over the constitutional rights and the safety of protesters.
Policing protests in the Western world continues to raise ethical and legal questions. In the United States, riot police have adopted militarized techniques that often violate citizens' civil rights. Marginalized communities are especially at risk of police brutality. Furthermore, protesters often have to navigate highly restricted legal avenues if they wish to obtain redress. While law enforcement in the US is fraught with issues of brutality and racial discrimination, we can continue to push for progress. Successful reforms in even one jurisdiction have the potential to influence change around the world. On behalf of the McGill Law Journal, we would like to graciously thank our guest, Professor Karen Pita Loor, for having shared her thoughts and expertise on protest policing. We'd also like to thank Professor Mugambi Jouet of the McGill Law Faculty for his assistance in connecting us with Professor Loor. Thank yous are also due to Alexander Shamaloev for our theme music. This podcast was produced by Laiba Assad and Aaron Gao.
All of our podcasts can be found free on Apple Podcasts, Spotify, and on our website at lawjournal.mcgill.ca. We welcome comments on our podcast on all platforms, on our Facebook page, on Twitter, and via our email at journal.law@mcgill.ca. Thank you for listening, and we'll be back soon.